How to terminate an employment contract.
There are several types of termination of an employment contract. The most common are the following. The resignation. This is when the employee decides to terminate the employment contract. The employee usually must give notice before leaving the job. Then the end of a fixed-term contract, CDD. This is when the employment contract comes to an end on a planned date. It can be renewed under certain limits. Then the dismissal. This is when the employer terminates the employment contract for a reason defined by law, like gross misconduct, medical unfitness, job loss, and so on. The employer must follow a specific procedure to dismiss an employee. This procedure varies depending on the grounds for dismissal and the legal provision in the collective agreement. In general, the employer must inform the employee of the decision to dismiss in writing, stating the reasons and indicating the possible means of appeal. The employee is entitled to a notice period, which allows him or her to remain in the job for a certain period before the end of the employment contract. The employer can reduce the notice period by compensating the employee. The conventional termination. This is an agreement between the employer and the employee to terminate the employment contract by mutual agreement. The conventional rupture must be approved by the administration. This possibility of termination is possible since 2008. The process is that the parties agree together on the terms of the termination, in particular the date of the departure of the employee, the amount of the termination payment, and whether or not the employee can benefit from an employment insurance. The procedure for the conventional termination of an employment is as follows. After having taken the decision to terminate the employment contract, the employer and the employee meet to discuss the terms of the termination. They may be assisted by staff representatives or legal advisors, but this is not mandatory. Then they draw up a termination agreement, which must comply with certain formalities and be approved by the authorities. Once approved, the contractual termination agreement is effective and the employee received a termination indemnity, the amount of which is freely determined by the parties. It is important to note that the contractual termination cannot be imposed by the employer or by the employee. If one of the parties refuses to sign the termination agreement or if the conditions are not met, the employment contract continues. Since its launch, the conventional termination of the employment has become an increasingly common method of termination in France. In 2019, more than 460,000 conventional terminations were approved by the administration, which represent about a quarter of the terminations in open-ended employment contracts in France. It is important to note that each type of termination of the employment contract has its own rules and procedures and may have different consequences for the employer and for the employee. Do not forget to seek counsel from your HR advisor.